case actually went to trial in federal court in Los Angeles. And in the middle of the trial, the judge was informed that members of Nixon's, what they called the plumbers unit, attempting to plug leaks, the plumbers unit from the White House had burgled Ellsberg's psychiatrist's office, looking for information about him that would compromise him. And the judge was so outraged by that outrageous government misconduct that he dismissed the case. And so Ellsberg was never convicted. The New York Times was never prosecuted for publishing the Pentagon Papers. But leaks have now become a big 21st century issue, including leaks of information and documents that are alleged to injure the national security. Under the Obama administration, 6 alleged leakers have been or are being prosecuted. That's twice as many prosecutions of leakers as all previous administrations combined. And the administration is investigating a lot more. The Attorney General Eric Holder last June directed 2 different United States attorneys to investigate various leaks. One of them was a publication of the information about the kill list, how we identify people, whether they're American citizens or not, that are going to be targeted by drones around the world. That was due to a leak. And then there was a computer virus that we apparently tried to disable the Iranian nuclear program with, and that was the subject of a leak. And there was a double-agent failed bomb plot in Yemen that was leaked. And you wonder why there's all this increased prosecution and increased focus on leaks. I don't think it's deliberate Obama administration policy. I mean, I take him at his word, Obama, when he says he wants to make this administration the most transparent. But it's not so transparent, and they're very concerned about these leaks. Some of the investigations and prosecutions were inherited from the Bush administration. For example, the New York Times reporter James Risen, who wrote a book called State of War that includes a chapter about how the CIA constructed an elaborate, fantastic plot to get a Russian to deliver nuclear information to Iran that had flaws in it, that would sabotage their program. And the Russians saw through it right away, and the whole thing fell apart, and it was sort of an embarrassment. Well, Risen included that in his book, this whole episode, and the administration was extremely upset by that. They tracked down the CIA agents that the government says leaked the information to Risen. Jeffrey Sperling is his name, and charged him with violation of the Espionage Act, disclosing this classified information to Risen. And they were able to track down Sperling largely because of the electronic trail that is now left. And that's a contributing factor to pursuing these leakers, because the government is likely to subpoena reporters and get their email communications, get their cell phone records, see who they were talking to, and then the government can finger the leaker better. This has sort of driven a lot of reporters who deal in this area to conducting interviews on park benches and not leaving an electronic trail for the government to pick up. It's also true that there's a lot of raw material out there now that can be leaked, confidential information. In 2010, which I think is the last year the figures are available for, the Obama administration classified 77 million documents. Secret, with the classification stamp on. That's up 40% from the preceding year. There are also 4.8 million government employees and contractors with access to that information, who have the requisite security clearance to get that classified information. So the opportunities for leaking classified information are wide open. How are we supposed to keep secrets if 4.8 million people are privy to them? I mean, it's a hopeless task. I think one of the reasons why the Obama administration pursues leakers is because the agencies, the National Security Agency, NSA, the CIA, and the other dozen or so national security agencies in the federal government are highly embarrassed and motivated to get those leakers. Nail those leakers. That shouldn't be what they're doing. And so they put the pressure on the Justice Department to do something about the leakers. Another factor that plays in here in this focus on leaking and the publication of national security information is the fact that there is no First Amendment protection for reporters' confidential sources. This requires some background, and you may not remember the events. This trio of folks here, Judy Miller was a well-regarded New York Times reporter for many years, and leading up to the Iraq War, she published some very influential articles basically supporting the Hawks view that Saddam Hussein had nuclear weapons, weapons of mass destruction, biological weapons, and was prepared to use them, justifying the invasion of Iraq. And she had developed good sources within the Bush administration, including Louis Scooter Libby, who was Vice President Cheney's chief of staff. And he would talk to Judy Miller, and she may or may not publish what he said, and certainly wouldn't attribute anything in an article to him. She treated him as a confidential source. And a lot that they talked about never reached publication at all. And then the government, the CIA, when the question was, does Saddam Hussein have nuclear capability and so on, they dispatched a man by the name of Joe Wilson, the CIA did, to go to Africa. It was alleged that Saddam Hussein was getting nuclear material from, I forget which one, Niger, I think it was, in Africa. And Wilson went down there and investigated and reported that there was nothing to it. That conflicted with what President Bush had said to the world in his State of the Union speech. And the administration was very unhappy about that. And Wilson wrote an op-ed piece in the New York Times disclosing his finding, which infuriated the administration. And all of a sudden, the name of Valerie Plame, Wilson's wife, was disclosed as a confidential CIA agent, undercover CIA agent who had been undercover in various parts of the world. And her name was leaked by someone in the administration, blew her cover. And a special prosecutor was named to investigate the source of that leak. And he interviewed and subpoenaed and gathered testimony from a large number of witnesses, including Scooter Libby, the chief of staff, who denied having talked to Judy Miller. He denied having having leaked the name of Valerie Plame. And the special prosecutor subpoenaed Judy Miller to testify before a grand jury about who her source was in the administration. She had been getting information in this general area, and she seemed to have relevant information. Well, she refused to testify. So I'm not going to obey the subpoena. The judge ordered her to testify before the grand jury. She refused. She sent to jail for contempt of court. And she served 85 days in jail in 2005, all this happened, for refusal to disclose her confidential source or any information received from a confidential source. And she had no First Amendment protection for that. She raised the First Amendment argument that reporters need to be able to protect their confidential sources, else they will dry up. If a source knows in giving, in leaking, in whistleblowing, in getting out to the public highly confidential information, that he or she will be exposed as the leaker and perhaps charged with violation of the criminal law of the Espionage Act, sources are never going to do that. Why isn't there First Amendment protection for reporters' confidential sources? Don't we need that? That's a subject we'll come back to in a minute. The leaker of recent times, the chief leaker, apparently, is Julian Assange of WikiLeaks. And it's a big question whether he and or WikiLeaks can be prosecuted for violating the Espionage Act for having disclosed 250,000 secret State Department communications and hundreds of thousands of communications from the military in Iraq and Afghanistan about events happening there. And Attorney General Holder has convened a grand jury to hear testimony about Assange. He has subpoenaed the Twitter accounts of various people who had anything to do with WikiLeaks. When Assange, as you know, he's hiding out now. He sought asylum in the Ecuadorian embassy in London. He's an Australian to begin with, but he sort of lives out of a backpack in various parts of the world, or he did, until he ended up in Sweden for a while, met a couple of young women there, had sex with them, and then went to London. And then the Swedish authorities start, right after the disclosure of all the State Department cables and so on, the Swedish authorities issue an international arrest warrant for Assange, saying, we want him brought in for questioning about accusations of rape. And rape is defined under Swedish law to include unconsented to sex. And the allegations against Assange is that the sex was at first consensual, but then again, on the second go-round, he did not use the condom that he had promised that he would use. That's what Sweden is calling rape. They want him back for questioning. He contested extradition from the UK to Sweden, and that took a year and a half to get through the Supreme Court of England said he's got to go, whereupon he ran and hid in the Ecuadorian embassy, where he still is. When he was interviewed on 60 Minutes, year before last, he said that WikiLeaks' founding values are those of the American Revolution, of Jefferson and Madison. And he's got a lot of that First Amendment rhetoric, and rhetoric about government transparency. Basically, WikiLeaks, in the earlier days, opposed government secrecy of any kind. And if anybody knew a government secret, they could get it disclosed on WikiLeaks. They were pretty indiscriminate about what they dumped onto the internet. But the big controversy came when Bradley Manning came on the scene. Private Manning is the alleged leaker to WikiLeaks. He's a soldier in Iraq who is one of those 4.8 million people who had access to a classified database on his computer that he was working on in Iraq. And he got upset one day when he saw the video of a drone attack in Iraq that resulted in the killing of a number of civilians, including 2 Reuters reporters. It was sort of a drone attack that went awry. And he, allegedly, he has not yet been tried, so the government charges him with leaking that video to WikiLeaks. Then he erased his Lady Gaga music from a bunch of rewritable CDs and recorded, allegedly, all these State Department cables and military communications out of Iraq and Iran and delivered them somehow or other to WikiLeaks, which then arranged to publish them. The Iraq ones were sort of unedited. They just dumped the Iraq communications. The Afghanistan ones, they were a little more discriminating about, and they actually deleted some of the sources of the information who might be endangered, might be killed if they were disclosed. Then the State Department cables, they negotiated, WikiLeaks, Assange, negotiated with the New York Times and the Guardian in the UK and Der Spiegel in Germany to publish those. He gave them to the papers to publish them. And before he released the cables, he wrote to the government, wrote to the ambassador in the UK, saying, you know, we've got all this information. People are saying that if we release it, it will impair national security. If you would please tell me which of these documents are so sensitive they shouldn't be published, we'll be glad to take a look at that and deal with the problem. That was just November 26, 2010. He gets a response the very next day from the lawyer, counsel for the Department of State in Washington, Harold Coe, who was a renowned constitutional lawyer and professor, I think he was dean of the Yale Law School before he went to the State Department. And he says that these documents were provided in violation of U.S. law. Disclosure would place at risk countless innocent individuals, ongoing military operations, cooperation between the countries. Does this sound familiar? And then he concludes that you got to ensure that you cease publishing any of these documents, return any and all classified information, and remove and destroy all records of this material from your database. John Mitchell could have written that. Nixon's Attorney General, in trying to stop publication of Pentagon Papers, said virtually the same things. Well, then Assange sort of politely responds the next day, saying, well, if you won't tell me, we'll go ahead as responsibly as we can. They went ahead and published. My thesis on the whole WikiLeaks phenomenon is this, that it virtually owes its existence to two weaknesses in our First Amendment protections. And that if we had these First Amendment protections, there would be little point to WikiLeaks at all. That is, we don't have, under the First Amendment, a constitutional right of access to government information. That the court held in a case that I lost that we'll look at in about a month, Houchins versus KQED. So if we had a constitutional right, a good one, to significant amounts of government information, there would be less need for anything like WikiLeaks. And secondly, as I said, there's no First Amendment protection for reporters who want to protect their confidential sources. WikiLeaks came on the scene right after the Supreme Court denied certiorari in the Judith Miller case. And that sent a clear message to reporters that they couldn't credibly, honestly, promise confidentiality to would-be whistleblowers. And just quickly, by way of background, the only case that the Supreme Court has decided on this issue, whether reporters have First Amendment protection for confidential sources, was a case involving Earl Caldwell, who had covered the Black Panther Party in the late 60s and early 70s for the New York Times. He was sort of an emissary to the Black Power movement in the country, and wrote several revealing articles about the Panthers, tell people what's going on with this phenomenon anyway, that the head of the FBI thought was a menace to the national security. Well, the FBI got a subpoena for Caldwell to come in and spill the beans, tell all he knew, bring in his notes and his memoranda and so on, and tell the federal grand jury what he knew about the Black Panthers. He resisted that subpoena. He was ordered to testify. He refused. He was sentenced to jail for contempt of court. He got a stay, and the case went up to the Court of Appeals, which agreed that he didn't have to testify, and the government took the case to the Supreme Court, which decided it in 1972 under the name of Brandsburg versus Hayes. There were three different reporters from three different parts of the country that had the same problem. And in an opinion by Justice White, the court decided that there is no First Amendment protection for reporters' confidential sources, and for a number of reasons. One is, who's going to be considered the press? If the press is claiming a special privilege that the rest of us don't have, that is the right not to obey a subpoena to come before a grand jury and testify what you know. You and I get a subpoena to go over to San Francisco and testify before a grand jury. We got to go tell what we know. It's secret. It's behind closed doors. Nobody will know what we said there. And reporters like Caldwell knew full well that if he complied with the subpoena and went over to that secret grand jury, that he'd never again get a Panther to talk to him. It would dry up his sources. Well, yeah, the court seemed to acknowledge that there's some protection for gathering the news, some First Amendment protection for gathering the news, as opposed to publishing it. Talking about a distinction here between speech, publication, and conduct, gathering the news. And yes, there's some concept. We'll acknowledge, Justice White is saying, some protection for gathering the news, but that doesn't mean that the press gets an exemption from the duty of all citizens to go tell what they know to a federal grand jury. And if we were inclined, the court says, to grant such a privilege, there's never been one. The press has flourished through 180 years of constitutional history without any such privilege. If there is such a privilege, who gets it? Reporters from the New York Times, and who else? What about book authors, academics, publishers, now bloggers? And White emphasized the theory of our First Amendment, which is that it protects not just the press, but all of us, including the lonely pamphleteer out there in the corner passing out her brochures, who has the same First Amendment rights as a publisher of the New York Times. And White and the majority of the court really didn't believe that sources would dry up if reporters didn't have this special privilege. So they ended up saying no First Amendment right to protect confidential sources. Well, WikiLeaks tells everybody on its website that it has never disclosed the identity of the person who's the source.